Hello, my name is Mary Henderson. I'm a senior staff attorney at the Land Loss Prevention Project. I've worked at Land Loss since 2006. I'm an attorney there, and we represent low-income landowners in North Carolina. So that includes homeowners and farmers on real property-related legal matters. That, of course, can include helping landowners prepare for and recover from natural disasters. My focus will be on how knowing the state of your title and clearing up title issues before a disaster can help owners of real property have access to disaster relief and recovery programs and benefits. I want to encourage landowners and property owners to consider title issues basically before a storm strikes. So, I'm talking about holding title to real property. So what does that mean? Holding title to land means that you have the right of use and ownership of that land. So what we usually think of is you have the right to enter the property. If there's a dwelling there or a house there, you have the right to live in it. We think of also the right to cultivate the land or farm it. If there are trees on the land, the right to cut timber, and the right to transfer your ownership to someone else. And the best way to demonstrate title, the most solid way legally, is with a deed. Land, of course, can also be passed on upon death by a will or by the operation of state law if the landowner does not have a will. And title can be held by one owner, or it can also be held by two owners or many owners. And we know that holding title to property is important for a lot of different reasons, right? You might actually live on the property, or you might use it for wealth creation, or to keep up with family and community ties. Land ownership and having title can give you the ability to access programs and services, including disaster relief programs. First, just as an estate planning plug, it's always a good idea to have a will in order to make clear your wishes for what happens with the property if you die. If you don't have a will when you die, then North Carolina state law decides for you what happens to your property. And as we will see, it oftentimes will spread out the ownership depending on who is alive at the time that the landowner dies. And passing property in this way without a will is called intestate succession. And when intestate succession happens multiple times over more than one generation, we often call that heir property, or you'll also see it written differently as heirs property. Oftentimes we'll see with our clients that a couple of generations can go by and you might get up to dozens or more owners. And as you can imagine, that becomes a more difficult problem to navigate for all sorts of reasons. One is that it can be difficult to achieve the benefits of property ownership if there are a large number of heirs or property owners. It can be difficult to keep track of actually who the owners are. You have to look at things like marriages, divorces, and deaths and births. It can be hard to keep in touch with all of the heirs. People may move away or lose contact with family members. It's also common for, of course, different people to have different levels of attachment to the land. It may be based on who lives nearby or who has the time or resources or connection to the land. That person sometimes takes on the burden of paying the taxes or trying to keep track of who the heirs are. And the law in with heir property basically envisions a scenario where all of the heirs share full rights and responsibilities. All of them can use the land, and all of them have responsibility to pay the taxes. We know this butts up against human nature and the ability of a large group of people to agree on how to handle any given situation. So with a fractionated ownership structure that comes with heir property, there can also be risk of losing the land through tax foreclosure. We do know that heir property disproportionately goes through tax foreclosure. Another legal threat is with partition actions, where anyone with an ownership interest can petition the court to divide or sell the entire property through public auction. So these are some of the reasons that people in heir property situations might look for ways to stabilize or consolidate their land ownership. At the same time, I do want to acknowledge that heirs can view their heir property ownership as promoting family bonds through communal ownership and management. Some families do have some success with developing ways to share tax payments. They may allow family members with the most need or with the most connection to the property to use it or live on it. So, the economic concerns may not always capture the less tangible benefits involving community bonds and preservation of rural life that may be part of owning a property. So in terms of documentation, it does make sense for heir property owners to track who is an heir and what their proportionate interest is. This relies on family information gathering and record keeping. So again, we are looking at births and deaths and marriages and divorces. So it's a good idea for heirs to work on complete a family tree as they can in order to determine who the heirs are and what their ownership interest might be. And again, trying to obtain current contact information for family members is useful, because these facts that we're gathering can change, of course. There can be a marriage or divorce or birth or death, and this information is always shifting. So keeping good contact information is important. One or more heirs can choose to work with an attorney to make sure the family tree is complete and look into deeds and probate files, estate files, and other records in order to determine who the heirs are and what their ownership interests are. An attorney can also help the heirs by giving advice about what their options are for consolidating title if they want to do that. And can also give advice on a new ownership structure, agreement, or other solution. Every situation is different, and there are advantages and disadvantages depending on the method that a family might choose. So there could be tax consequences or public benefit eligibility consequences, and of course the goals of the heirs themselves is the guiding principle. So one structure that heirs may want to consider with an attorney that fits their situation is a trust. For a family trust, heirs can transfer their ownership interest by deed to a trustee. For example, the heirs may choose one heir to be the trustee, someone who has that connection to the land or that interest in getting involved with the land. The trustee can hold and manage the land for the benefit of the beneficiaries, which can be all of the heirs. With a trust, there's a trust agreement that sets out the duties of the trustee and the rules for property management. Another entity to consider is an LLC, a limited liability company. Again, if it fits the heirs' needs and in consultation with an attorney, the co-tenants can create an LLC entity through initial filings with the North Carolina Secretary of State, and then they would deed their ownership interest to the LLC, of which the heirs can be the members. LLCs do require annual reports, and both the initial filing and the annual reports require fees. So that's something to consider. With an LLC, the heirs can have an operating agreement that sets out things like what happens to a member's share when they die, what happens if a member wants to sell their share. Oftentimes there might be a provision allowing other members to buy out anyone who wants to basically leave their membership in the LLC. Besides entities, heirs can consider making a written agreement that sets out who is allowed to do what with the property, and again, if one heir wants to sell their interest, it could give a right of first refusal to the other heirs, so that again, there's protection that allows the property to stay within the family. Tenants in common agreements don't actually change the ownership structure or consolidate title. Again, they're just a way for the heirs to agree about how they're going to handle their property ownership. If the heirs do want to consolidate title, besides using an entity, they could actually decide just to transfer their interest to each other, so that if only some heirs are interested in owning and managing property, then others could deed their interest and therefore consolidate title. Most or all of these options will probably involve costs. So there can be fees for attorneys. There can be fees if there's LLC filings. There can be fees for surveyors and recording of deeds. When you look at both these costs and the difficulty of getting a large group of people to agree on a single course of action, it definitely shows the challenges of their property, which some programs and legislation have begun to recognize that quick and easy resolution of heir property is not always realistic. And so, again, some programs are meeting heirs where they are as heir property owners. So, how do title issues in heir property in particular relate to access to disaster relief and recovery programs? Well, different agencies have different requirements for proving ownership. The easiest way is generally with a deed, but a deed is not always required. So FEMA, of course, is on the national level the main agency for offering disaster relief programs. Their individuals and households program provides financial help and direct services. And okay, so looking at the title issue, to be eligible for assistance, the residence must be owner occupied. And what that means under the regulations is that the residence must be occupied by either the legal owner, a person who does not hold formal title but is responsible for paying taxes or maintenance of the residence, or by a person who has lifetime occupancy rights, even though title is vested in someone else. And so FEMA will look to public records, including deeds and property tax bills, but we'll also look at documents provided by the applicant, such as bills that may show that they lived in the residence prior to the disaster. Other than FEMA, there are, of course, other agencies federally that deal with disaster relief. So with SBA's disaster home loans, their requirement is that the home must be the primary residence with the occupant or owner as the applicant. And again, they will rely mainly on documents like deeds and property tax records. USDA, which of course has a large number of sub-agencies that provide disaster relief. They may require the farmer to be an owner-operator or a tenant-operator, and they might require documentation of either ownership or tenancy. In 2018, there was a helpful provision that was advocated for by a number of organizations, including Land Law, that included a provision for farm operators on air properties to be able to obtain a farm number that would allow them to access FEMA program. And to be eligible, those air property owners could show that they have a tenants in common agreement, that they have tax returns showing income from farm operation in prior years, and other documentation. So we can see that knowing the state of your title and having documents secure, as well as taking steps to clear title if necessary, can help landowners access recovery and relief programs in the event of a natural disaster. I want to say thanks very much to the NC Pro Bono Resource Center for the opportunity, and thank you for listening. This is contact information for the Land Loss Prevention